This podcast is designed to provide general information. It is not intended to be legal advice. It cannot and should not be substituted for proper legal representation. You should consult an attorney for legal advice regarding your rights, as every case is unique and requires in-depth analysis and preparation. Welcome to our second podcast hosted by the Mishiyeva law firm. We are located at 85 Broad Street, New York, 10004, and our number is 646-736-6328. Also, you can visit our websites at www.nycprobatelawyer.com and www.kmbankruptcylawyerny.com. Today's podcast is all about wills, so let's get right into it. What exactly is a will? Well, it's a legal document that expresses your choice as to how you want your property to be dispersed and to whom it should be transferred to. The will also discusses how your minor children should be dealt with. You essentially decide who the guardian should be. This applies to disabled adults that are under your care as well. So there are 4 types of wills you would normally hear about. The first is a testamentary will. It's a traditional will that people generally tend to opt in for. It's a formal document that is signed, notarized, and includes the attestation of witnesses in its making. Then you have an oral will. It's not documented. It is actually expressed verbally in front of witnesses. We do not recommend this option. Then you have what's called a holographic will. It is documented, but it lacks actual witnesses. Again, we do not recommend this type of will either. And then you have what is called a living will. So even though it's called a living will, it's actually completely separate from the other varieties that are out there. Reason being, it doesn't actually discuss the transference of property at the time of your death. Rather, it only gives directives as to what should happen to you when you become incapacitated and you are subject to life support. So what are the benefits of a will? Well, when you have a will, there is an added measure of control to your affairs. You decide who should receive your property. You decide what should happen with your minor children and who should have custody of them. You also decide who to include and exclude in your will. If there is no will, there is a possibility the court will make all of these important decisions on your behalf. Another benefit to a will is keeping peace within the family. You have seen it in movies and you read it in books where a large estate was at stake and there was no formal will. Fights, arguments, and feuds can sometimes result because of this. This is completely unnecessary and completely avoidable when a will is created. Be aware, although you can specify what should be transferred and to whom in your will, certain assets are not included under the umbrella of a will, such as proceeds from a life insurance policy, community property, and retirement assets, just to name a few. So let's say there's no will in place. Does the government take your assets away and do as they please with them? The answer is absolutely not. In a situation where there is no will, and by the way, we highly recommend you try to avoid this happening, and we prefer you actually go out there and get a will for yourself, but in a situation where there is no will, the court typically decides what your heirs should get based on a specific formula in place. Usually the spouse gets half of your property and your children get the other half. Let's say there's a house in which your spouse currently lives in, but everything now has to be split. Chances are the house will have to be sold and liquidated in order to satisfy the judgment. So one of the biggest concerns with a will is the fact that it has to go through a process called probate. So probate takes place within surrogate's court, which is where you would normally submit the will. And when the will is submitted to surrogate's court, the court must now validate the will to ensure it is in fact real and valid. That's essentially what probate is. It's the process of validating the will. So this process can take months and sometimes even years. Also, a will contest could occur during the probate period. That's when an individual files a petition challenging the validity of the will by either stating the entire will is fraudulent, the decedent was coerced in making the will, or the decedent was not in a sound state of mind when drafting the will. All this can lead to long, extensive legal battles, attorney fees, and other expenses required to be paid that will be incidental with the situation. So how do you ensure your will be upheld? Well, there's various safeguards you can take, and just to name a few, what you can do is prior to drafting the will, go for a doctor checkup or medical checkup and request the doctor to attest to the fact that you are mentally sound and make sure they have it documented. It's possible people could come around and say, you were dealing with depression or psychosis when you wrote the will, therefore it should be invalid. So by going to a doctor and having them document that you are actually, pretty healthy mentally, that will work well in your favor in case that is ever an issue that comes up in court. Also, make sure you have your will notarized, and we would say gather at least 4 witnesses for the will. Try to get witnesses who are healthy and somewhat young. For example, a 90-year-old witness won't do much good if you're expected to live for another 30 years. What happens when you pass away? Chances are that 90-year-old will also be, dead at that point. So we recommend you get people who are somewhat healthy and of a reasonable age. This way they can come to court and bear as witnesses for your beneficiaries in the event somebody does challenge the will. And it's okay to get a little creative. You probably own a smartphone. It is 2015. Why don't you take a video of you reading the will with some of your witnesses present? I'm sure that'll be a great piece of evidence to the judge in surrogate's court in case the will is ever challenged. So my question is, have you ever actually seen a will? Usually it's several pages with various clauses and directives by the decedent, which is the person who passed away. And finally, on the last page, there's a space for all the signatures and notary stamps. I think this is certainly adequate, this type of will, when you have a traditional family and the will merely emphasizes that your property should go to your children and your spouse, and also your spouse should now be the guardian of your kids. But let's say you're in a situation which is not very traditional. For example, say you're in a same-sex marriage and you have a child living in your home who you care for, but they were not actually officially adopted. Or suppose you care more for your best friend than you do for your immediate family, and you prefer she should be your only beneficiary and everyone else should be disinherited. Do we recommend a will to have all the signatures on the last page? Not really. As an added measure, whenever you have directives and clauses that are very impactful, like when you want to disinherit an immediate family member, have space available near that specific clause for your signature and the signature of your witnesses. This is just simply an added measure, and it reinforces your emphasis on the clause in the directive. So, how do you go about in making a will? Well, there's a ton of software and templates out there where you can go ahead and create your own will. There are also various document agencies that can make a will for you at their premises. We, however, highly recommend that you instead visit a lawyer who specializes in estate planning, will and trust drafting, and estate administration. Why? They have the training, they have the experience, and they have the education to understand all of the various nuances that appear in wills which could adversely affect your beneficiaries. It may cost more than just using a random template, but that added measure of security and predictability will all be worth it. And that concludes today's episode. Again, we're the Mishiyeva Law Firm. We're located at 85 Broad Street, New York, 10004, and our number is 646-736-6328. And please visit our websites at www.nycprobatelawyers.com and www.kmbankruptcylawyerny.com. Until next time, thank you.